Hi everybody, this is Marisa Portuondo, and this is the second day of our litigation series where I will explain the different stages of litigation. We understand that litigation can be extremely stressful and very confusing for non-lawyers, and I would love to ease some of that stress and clarify things for you as much as possible. So yesterday we spoke about the summons, and today I want to speak about the complaint. The complaint is basically what is known as the lawsuit. As briefly touched on in yesterday's video, the complaint gets attached to the summons and they get sent out together via a process server or sometimes a sheriff to the defendant. So as you've seen in the movies, when they say like, you've been served, that's the summons and the complaint being sent to you. Now, a complaint can be extremely short, and it can be hundreds of pages long. It really just depends on the case. Many times there are exhibits that go along with the complaint. Sometimes the exhibits are longer than the complaint itself. Contracts, all kinds of supporting documents are sometimes attached to the complaint to, strengthen the allegations and to prove certain things. In some cases, exhibits are required to be attached, as in the case of a breach of contract. Anyway, if you receive a complaint, you have in Florida 20 days to respond to it. So if you are on the plaintiff side and you're waiting and waiting and you're wondering why nothing's happening with your case, remember that the 20 days starts from the date of service, not from the day that your attorney files the lawsuit. So if the person is extremely hard to find, if they're evading service, if they haven't complied with, as a business, with the requirements of having a proper registered agent, it can take quite some time to serve a defendant. And remember that those 20 days, that countdown does not start until service is completed. So just something to think about if you're on the plaintiff side. Now, if you're on the defendant side, when you get the complaint served upon you, it is extremely important, as I said yesterday, that you contact your attorney immediately. Why? Attorneys are extremely busy people. Most of the time we are managing, several cases. Some attorneys have hundreds of cases in litigation at the same time. And so it's really just not fair to all of our other clients to drop what we're doing on their work and deal with an emergency. So, many attorneys will either turn you down, they may charge you a premium for rush work. They're going to be stressed out and rushed in responding, which is not what you want. So, many times if it's getting too close to that deadline, what the attorney will do is have to request an extension. Now, this might sound great because it's, that much more time before you have to deal with it, but it is going to spend, it's going to take more time on that attorney's part, and that means it's going to cost you more money, more than likely. So really the best bet is to just contact your attorney immediately so that you can discuss what is happening. You can go over all potential defenses. You can develop a strategy. If the attorney has questions or paperwork that they need to review in order to properly respond to that complaint, then the sooner the better. We will talk tomorrow about the different responses that are available. I may actually split those up because it's a little bit intricate, but that is what we will discuss as the days are coming. All right, I'm going to say goodbye here. Have a great day.